we have Magnolia Investments LLC versus City of Hudson et al. For record-keeping purposes, this is case 29392. In this case, Magnolia is the appellant. Again, you'll have 15 minutes to present your argument. I've already told you want to reserve 5 for rebuttal, so we can proceed.
Thank you very much, Your Honor. Again, my name is Steve Bond, here with my colleagues Dan Wright and Chris Teodosio. We're here on behalf of Magnolia. Mr. Fritz, the principal of Magnolia, has been trying to develop this property legally since 2014. He came in with an original plan which would have involved removing the existing building and building brand new. City fathers didn't like that. Turns out that this was a 1930s kit house that had some kind of significant historical value. He accepted that. He came in with a new proposal to remodel the house and got all the permits from the city and the county that were necessary, and no one objected. First step was he knocked down the old garage in order for them to be able to maneuver on the property. Then he goes all in, he jacks up the existing building off of its foundation, and that's what this picture is showing you. At the point that when he got to this point, the chart showing you, he had invested about $83,000 into this project. He removes the old foundation, but the Historic Review Board of the city, as a condition of the approval, required that he have specific kinds of bricks to replace the old bricks. And when he goes to apply for those, it's in the record, he went to the sole source supplier of that, and they told him, well, because it's winter time, we aren't producing those bricks. They won't be available for 6 months. So a 6-month delay was built into the process from day one. He gets the bricks, builds a new foundation, lowers the house, guts the inside of the house, but maintaining the facade of the outer edges of the house. At this point, his investment rises up to $171,000. Goes in, replaces all the interior walls, takes out the wiring, the plumbing, the HVAC, all of that is replaced. Now he's up to $209,000. These numbers, they're all in the record. There's testimony by them. He frames in the replacement garage, which had to be moved because in order to get the equipment in to move up the house, that had to be gone. Now he's able to put the garage back. He frames that in. He sheathes it in with walls and roofing, and he ordered and delivered all of the materials that were necessary to complete this, and those are on site. Total of $244,000 of investment. We get to the time when the city came out to object to this, and at that point in time there's a porch on the front of this house. The porch is there, the floorboards are not there. And there's some railings that need to be added, and they need gutters and downspouts. But for that, this house was complete and ready to go. The city stopped the work when 2 or 3 days of work were necessary to complete the house. Was the garage done yet? No. We agreed to that. But also, the record is clear that prior to the end of the 2-year period, the footers were in place and approved by the city inspector. We ended up before the zoning board, and all of these facts that I've told you and many, many more were in the record before them, including the facts in that chart down on the bottom there showing the continuous progress of this job from one step to another in accordance with the investments that are shown in the chart on the left. The interveners tried to prevent that evidence from coming in, but all of the testimony supporting it was admitted. And no one limited the city or the interveners in presenting any evidence that they wanted to that would have been in opposition to our arguments. In fact, the interveners intentionally rested without presenting any witnesses. And we already know from Judge O'Brien that the board made the fundamental error of contending it didn't have authority to consider the extension. And based on that premise, the board then refused to go ahead and evaluate the evidence that was in front of it and refused to allow admission of Exhibit 7, which was all of the billing and receipts that documented all the expenditures that had been made. Those fundamental numbers are in the record. What are the elements of those numbers are the documents that are before you, but which the board said it was not going to consider. Ordinance 120203 gave the board the authority to take action on the appeal. In other words, it should have considered the entire record at that time if they had not been misapplying the ordinance. And they would have come to the decision, they had to have come to the decision, that there was continuing work being done on this throughout that 2-year period, and therefore they should have awarded the extension of the certificate at the time. Judge O'Brien, while she agreed that they were wrong, is giving them all a do-over, saying, well, I'll remand this. There's no reason for a remand. All of the evidence that supports the fact that we met the conditions for that is already there, and the city and the interveners elected not to oppose it. I direct the court's attention to the Shaker-Coventry case, which is in our brief, in which the owner wanted to build some apartments. The zoning was single family, and he applied for a permit and it was denied. The zoning board claimed that it had no authority or jurisdiction in the matter. But the trial court said, in reversing, that it was not going to allow an arbitrary refusal by that board to consider the appeal to have prevented them from being awarded the permit. And the trial court used its full equity powers in that case to order the zoning board to allow the permit. When the case came to the 8th District, that court said the peculiar proposition advanced by the appellant, the city in that case, is that because the Zoning Board of Appeals refused to take jurisdiction of this matter, the trial court was also without jurisdiction. This, in our opinion, is a fallacious argument. If this contention were sound, no relief could be granted to any property owner who felt aggrieved. Under the overwhelming weight of the evidence, as shown by the record, it is quite certain that the zoning ordinance, when applied to and limited to the subject property, is confiscatory, arbitrary, capricious, and has no reasonable relation to the health, welfare, morals, and safety of the community, and thus constitutes a taking of property. In other words, both the trial court and the Court of Appeals agreed that they had the authority to order that the permit be approved. And because the evidence in this case is uncontroverted, this court, in considering this as an issue of law, also has the authority to issue the order to the Board of Zoning Appeals, which the trial court should have done. And I direct your attention to the case of this court, Davis versus Barberton, in which there was a question of raising a nuisance property. The zoning board ruled against the owner, and the Court of Appeals said, without a single piece of evidence to controvert Davis's valuation before it, the board could not have properly determined that it was appropriate to order demolition. As a matter of law, it was error for the board to order the demolition despite the uncontroverted evidence of the property's value. This court issuing the order to direct what the Board of Appeals and the trial court should have done. I want to briefly shift attention to the February 13th letter from Mr. Hannon. We have an we have an investment of $250,000. We have a house that needs 3 days' work to be completed, and we have a stop work order, which, as it turns out, has now been in effect since that time. There has been no work done except to patch a hole in the roof when there was a bad storm that was allowed by order, in conjunction with the other parties in the court. And if you look at the letter, not only does he inexplicably change his whole concept of whether or not an extension was allowed, but he says, now you must get a new certificate, you must conform to current regulations, not those of 2015, and this includes a change in the surface coverage from 60% to 40%. In other words, a significant, effective limitation on the person's ability to use that property. And you must follow the current procedures. If you look at the Jackson Township case, we have extremely similar fact situation, and the lesson of that case is that even though the court says that there is no non-conforming use under the terms of their ordinance, nevertheless, there is a constitutional property right that exists, that when the use is already in existence at the time, a use regulation to the contrary cannot be used to divest that party of its rights. And the test for whether it has vested is relying on whether there's been a substantial change of position, expenditures, or significant incurrence of obligations in reliance on the zoning permit.
So you're into your rebuttal time.
Thank you.
Keep going, I just want you to know.
Okay, and in this case, all three of those criteria are clearly met. A $250,000 investment, jacking up the building off of its foundation and replacing it with a new foundation, and investing all this time since 2014 and allowing it to stand unused for the last 2 years, all demonstrate that there is a vested right. The ordinance that was recently enacted by the city merely demonstrates an additional change to the ordinance, to the ordinances that may theoretically be applied to this. And we cite it only because if you read the city's brief, they're constantly making reference to the fact of there can be no vesting issue unless there's been a change in the law. Well, Mr. Hannon already told us that there was a change in the law, and now everyone in the world, except apparently the objectors, knows that there's been a new change in the law that would require the landowner to cut the top third of the garage off. For all these reasons, we urge the court to reverse the decision of Judge O'Brien with respect to the question of remanding the case, and we ask you to issue an order directing the Board of Appeals to issue the zoning certificate that was requested in compliance with, and require them, or allow us to comply with that certificate in accordance with the 2015 regulations. Thank you.
How are you going to split your time?
Your Honor, Mr. Warhatch and I have agreed that I'll take up to 10 minutes and that he'll have the remaining 5 minutes or more. Just in response to the facts that were set forth here today, I think it's very clear that it was 89 days after the 24-month deadline that the extension was requested, giving them approximately 3 months extra to actually, or 82 days extra to complete the construction, and certainly the house could have been completed within that period of time according to the record, as well as the fact that they knew in the fall, that Magnolia knew in the fall of 2015, October of 2015, that it was going to take 6 months to get that split-faced block for the foundation to be able to have that. So it was well early on in the 24 months. Nevertheless, let me introduce myself. And my name is Todd Hunt. I'm from Walter Haverfield Law Firm, and I am the former city solicitor. I was not the city solicitor during the time that this was going on. However, I have been appointed when I retired from being city solicitor. I have been appointed by the city as its special counsel and do all of their litigation. And I'm representing the appellee here today, which is the city of Hudson and the officials and Board of Zoning Appeals that were named in this administrative appeal, which was probably not appropriate to actually name all those others, or not necessary. As you are aware, the city did not appeal the trial court's decisions. We have, make no mistake, we would like to see this project completed as soon as possible, and very expeditiously, and we've been attempting to do that for the last year and a half, but nevertheless, Magnolia has been hung up in a procedural quagmire of their own choosing. They chose probably the least pragmatic approach to try to get this resolved. They chose to seek relief from the stop work order by applying 89 days after. And then when it was denied, based on the clear language of the ordinance, even though the city's not contesting the trial court's interpretation of that. They then appealed to the Board of Zoning Appeals, giving some standing to neighbors to object, which is what happened here. And so we've been caught up in this ever since the Board of Zoning Appeals hearing and subsequent administrative appeal.
This may be a stupid question, but was mediation ever attempted?
What's that?
Did you ever attempt mediation of this?
We have attempted to settle it, yes. I wouldn't say mediation, but we've attempted to get the parties together. And in fact, the city manager has gotten the parties together without the lawyers trying to resolve it, and over the last year and a half.
But to follow up with Judge Schaefer's question, you've not had a disinterested impartial party that's been involved to try to help resolve the...
No, other parties felt it was not fruitful to do that through the Court of Appeals mediation process.
Well, we started a new program. Been very successful.
And so that's where we're caught up in it, and I think the Common Pleas Court was absolutely correct in its holding with respect to the vested rights issue. The vested rights issue as it relates to the denial of the extension is not ripe for review and is moot at this point. If you look at the different scenarios here that could result from your decisions, possible decisions, is that if this court upholds the Common Pleas Court's decision to remand the case back to the city to determine if there was an extension that was warranted based on continuous construction, and the city extends, then Magnolia proceeds with completion as it wishes to do and the city wishes it to do. If upon remand the city does not extend the zoning certificate because for some reason it finds that there wasn't continuous construction during the 24-month period, or there was some, because of the delay, the delay was not legitimate for some reason, which none of that is present here, it can still apply for a new zoning certificate, and it's very likely to be granted to the applicant based on the situation that's before us. And then the third scenario is if the court reverses, as Mr. Warhatch has argued in the earlier case, and upholds the director's refusal to extend, they still have the right to reapply for a zoning certificate, go through that easy process, essentially. It's likely to be granted, and if it's not granted, there's always the issue of applying for a variance from the BZA based on the circumstances that they find themselves in this situation. The stop work order in and of itself did not create a constitutional violation of any kind, and it seems that the cross-appellant here, Magnolia, is arguing that a municipality cannot impose a deadline on completion of a construction project, and of course the rationale for that is you don't want partially completed projects to sit out there for a length of time that are unsightly and
this is what's happening
consume
here.
safety concerns. Exactly.
And that's
We don't
what's
want
happening.
it to happen.
But it seems like everybody wants to get this resolved.
Yes. Well, the city would like to see it resolved. And I'm sure the owner would like to see it resolved.
For whatever it's worth, and continue to go on, it's between you and Mr. Warhatch.
Okay,
Your turn.
just maybe one more minute, and that is really a vested right does not ripen until there's a final absolute denial of having a completed project, or it's here, a completed building, through the municipal administrative processes, and there are adequate administrative processes going forward to apply to get this finished. And we would ask that, respectfully ask that the court uphold the trial court's decision with respect to the appellant's, cross-appellant's assignment to their number 3 and number 4 related to the vested rights. Thank you.
May it please the court, I'm David Borhatch on behalf of the intervening appellees and the appellees in this case, 29-392. I just want to address briefly a few of the issues. I align myself entirely with Mr. Hunt's arguments with respect to the vested rights issue. The judge got this issue absolutely correct in her decision. Since they have still opportunities to accomplish what they're seeking to accomplish, whether procedurally by filing for a new application for zoning certificate, or by winning the case on appeal, and then the case gets remanded to the Board of Zoning Appeals, the Building Appeals, they still have opportunities, so they haven't yet been harmed in that respect.
Let me ask you a question.
Yes, ma'am.
How do the interveners have any real say in anything whether it's a vested right?
By definition
really
in the zoning,
impacting it.
by definition in the zoning code, anybody that lives within 300 feet of the boundaries of this property have standing to attack anything that's being done on the property.
Well, no, I understand that. What I'm saying is, the issue we have in front of us now, the other case has already been argued in front of us, okay?
Yes.
And the issue we have in front of us now is, was it a vested right?
No, there's two issues here. They've also claimed that the judge got it right, but she didn't go far enough. We align ourselves, since they raised the issue of vested rights, we put a little bit in the brief for that. But we also believe that
But you're
the
really
judge did the right thing on the
issue.
remedy.
Okay.
That is an abuse of discretion argument that I don't think they've made in their brief correct enough to persuade this court. Here's the fundamental issue on this. Remember, this is a Chapter 2506 appeal. It is not just an ordinary case that comes through the courts. It's a special proceeding. The court's jurisdiction, the power of this court to act, is limited by what the Board of Zoning and Building Appeals could do. You can't just fashion an order that they're asking you to do, basically saying, yes, but the judge should have entered a judgment in your favor and given you the extension. That is not the case. The court does not have the power to do what the Board of Zoning and Building Appeals cannot do itself. Under the city's ordinances, the director or the city manager are the only ones that can make the decision to grant an application for an extension. So when this is remanded to the Board of Zoning and Building Appeals, the Board of Zoning and Building Appeals will have to then refer the matter either to the director or the city manager to make the decision in the first instance. Then if anybody's disappointed by that decision, you can appeal it to the Board of Zoning and Building Appeals, whose jurisdiction is limited to reviewing the propriety of that decision based on the record. That decision was never made. In fact, all this evidence, all this argument you heard about uncontroverted testimony about how much money was socked into this project was deemed by the Board of Zoning and Building Appeals to be irrelevant. That's why you don't see any controverted evidence. We didn't have to bring any. The Board of Zoning and Building Appeals properly directed its efforts to looking at the question of whether or not the letter that Mr. Hannon issued, saying that he doesn't even have the discretion to grant an extension because you came to the 89 days after the zoning certificate expired, whether or not that was a proper interpretation of the ordinance. That is the only thing that was before the BZBA, and so therefore Judge O'Brien was correct in referring the matter, if you're going to reverse the case at all, referring the matter back to the BZBA for further proceedings not inconsistent with the court's opinion. Now, we, of course, have told you in the previous case why we think the judge was wrong, but if you agree that she was right, then you can't upset the discretion she properly exercised here to make sure that this question is ultimately decided in the first instance by the Director of Community Development or the city manager, and then by the BZBA only after that decision is made. I agree with Mr. Hunt with respect to the issue of when the block issue came to their attention in the fall of 2015. That would have been a perfect opportunity for them to invoke this ordinance. And they could have said, we want an extension because we are told it's going to take 6 months to do this. They proceeded without asking for that extension. That to me is their own conclusion that they could complete the project within the 2 years' time. But they could have made the extension hoping that they wouldn't need it. But they didn't do that either. The ordinance makes it clear that that option is available to them. You've heard issues about the changes in the ordinance since they got their zoning certificate in October of 2015. The most recent changes, as you know, are not in the record. The changes that Mr. Hannon is referring to are changes that would have been made available that they would have known of. But if they had applied for the extension, they could have made sure that any such changes would not apply to them. They only apply if they wait and then have to apply for a new zoning certificate. The problem here is that they waited. These are all errors of their own creation here. If they thought that they were not able to meet it within the 2 years, they should have applied for the extension. The city would have looked at it in a different way than it does now. Because what it says is, our ordinance means something. We want these done within 2 years. If you can't do it, you must come to us and explain why. And they didn't do it in this case. You heard him refer to the impervious surface ratio issue, although he didn't call it the ratio question. He talked 60%, 40%. I'm going to tell you that under the plan that they approved, we believe that they miscalculated that ratio under even the 60% standard. So we think that the evidence ultimately will show that they don't meet the 60% standard, let alone the more restrictive 40% standard that's still there. We also think that there are height problems. Talked about mounding. It's interesting, they mounded around the foundation of the garage. And the garage can only be 25 feet tall. But if you mound it up, you can build it higher, is basically what I just heard them say about the Green case. Seems to me that's what they've done. But we think that that is not consistent with other ordinances that the city has in place. And we also think there's an issue with respect to setbacks, which need to be addressed under any application for new zoning certificate. Be that as it may, the problem is that in this situation, everything is of the owner's own making. They could have solved this problem early on. And the issue with respect to settlement, Judge Schaefer, is this. I took the initiative to try to get the parties to try to talk about settlement in this matter. It's not in the record, but I'll just say the following.
Objection.
Well, the judge asked the question, and I took the initiative.
No, the judge asked, I'm sorry, Judge.
Time's winding.
Okay.
Okay, wrap
Very
it
fine.
up without addressing that issue.
So ultimately, we think that the court ultimately cannot provide the remedy that they're asking for.
Okay.
Because the Board of Zoning and Building Appeals does not have the power to do what they're asking until the director or the city manager makes that decision in the first instance.
You know that the city likes to make this sound like this is a problem of our own choosing. It's not a problem of our own choosing. Mr. Fritz did what Mr. Hannon told him to do. He told him, ask for an extension, and that's what he did. And Mr. Hannon wrote back and said, okay, we got it, and we're going to give it consideration. Counsel for the city used the term continuous construction. I'd just like to point out that's not, the ordinance does not use the word continuous construction. It uses the word continuing construction. I think there's a difference. Continuous suggests something that is ongoing without ever stopping. Continuing can have stops in the middle and still be continuing construction. The city, in its brief and today, has made the assertion that it is very likely that the city will go ahead and approve this if only we just stopped in and asked for a permit. With all due respect, I think that the city should get some kind of a special Pulitzer Prize for outstanding effort in appearing to convincingly guarantee something in a way that a citizen could rely on and find out that it is entirely unenforceable. Very, very likely to get a permit is not the same as you will get a permit, and that's why we are forced to continue with this appeal. When we talk about a vested right, it means, I believe, that there is a point at which a landowner commits to the development of property with his money, sweat, tears, to the extent that he gains a right to continue to use it for that specific purpose. We believe that when you have a house that needs some boards put on the floor of the porch and a gutter on the roof, after investing $250,000, you have more than reached that point. This court has the authority to do what is right. And that's what the Shaker Coventry Corporation decision from the 8th District says. The zoning board should not be permitted to just say, we can't do anything about it. And then as a result of that, the landowner has no option. This court has the authority to do what is right. And on that basis, we're asking you to reverse the trial court and issue instructions directing the zoning board to revoke the stop work order and reinstate Magnolia zoning certificate.
Thank you. Thank all of you for your presentation.